Thanks. Good evening and welcome to the June 30th, 2021 meeting of the Holliston Zoning Board of Appeals. To start the meeting, I want to read this into the record since we're meeting remotely. Pursuant to the Governor's June 16th, 2021 Act relative to extending certain COVID-19 measures adopted during the state of emergency, suspending certain provisions of the open meeting law, GL Chapter 30A, Paragraph 20. The Zoning Board of Appeals will be using remote participation for this meeting. The audio of this meeting is being recorded and will be posted to the town's website within 24 hours in accordance with keeping the public informed of actions during this meeting. I would ask that all participants remotely attending this meeting please state your name for identification purposes each time you speak throughout the meeting. At this time, a roll call attendance vote of the committee will be taken. John Love here. Jay Peabody is absent. Mark Bush.
Present.
Elizabeth Dembitzer.
Here.
Thank you. So we have a quorum. We'll proceed with this. So the first order of business that we have is the approval of the April 28th, 2021 meeting minutes. I know we looked at them last time, but is there any corrections or questions or concerns about that?
No.
I had none.
Yeah, and I wasn't there on the 28th.
Oh, that's an easy one then. Okay, if we could have a motion to accept the meeting minutes as written.
I can do it. I'll make a motion to accept the April 28th, 2021 meeting minutes as written.
All right, I will second it. All those in favor, John, aye. Mark?
Abstain.
Abstain. Liz?
Aye.
Motion carries 2 votes to 0, 1 abstention. We have a variance extension request at 36 Cranberry Lane. I'm not sure I saw anything on that. I'm sorry.
Do we have to approve, sorry, do we have to approve minutes for June 16th? Or no?
Well, they're not on the agenda, so we'll hold those until it, I don't, yeah, we could, but.
I have it on the agenda.
Oh, okay. Maybe I'm looking at the older one. Shoot. Okay. Then in that case, yes, let's bring that on. Are there any questions or corrections to the minutes of June the 16th, 2021?
None for me.
Yeah. Liz, anything from yours?
No.
Likewise. So if we could have a motion to approve those.
Make a motion to approve the meeting minutes from June 16th, 2021, as written.
I'll second it.
Moved and seconded. Further discussion? Hearing none, we'll move to vote by voice, roll call. John, aye. Mark?
Aye.
Liz?
Aye.
Motion carries. Minutes are approved. Yeah, now we have, let me make sure. I'm looking at what Karen sent the other day, so it must be a newer one. For June 3rd, but you have variance extension request at 36 Cranberry Lane, right? I'm not familiar with that one, I'm afraid.
John, I think you're looking at an older agenda. We took that off the agenda. Attorney Winter had issued an email saying that Attorney Barberi had misinterpreted the extension, the COVID extension on that permit. So it remains valid. He may ask for an extension.
All right, so I pulled up the earlier version of the minute. Let me see if I can grab the right one so I don't keep doing this. Apologize.
I have that on the one I just pulled today, though.
Yeah, and it's
Sorry,
the one that's online too.
Yeah, I'm sorry, it shouldn't be.
No, I just want to make sure I have the right version.
Yeah, you don't need to take any action on it.
Okay. Oh, shoot, just took that down. So now I just pulled down. Is the next thing on the agenda the dimensional variance at 115 Fairview? Okay, thanks. I'll pull
Yes,
that up. Sorry for the confusion. We're doing okay. That I think I saw Mr. Phillips. Will ask you to present that.
Yes, I'm here. I think I'm unmuted now.
Okay. Yep, you are. We can hear you. Thank you.
Okay. All right. First off, I'd like to say I would have preferred to be meeting with everyone in person to present my application, but it is what it is. So we'll make the best of it. My name is Wendell Phillips. I am president of Phillips Luxury Homes. I am submitting the variance request for 115 Fairview. And I want to begin by stating our original application was submitted in May. And the owner listed on this was Bruce A. Isidore, trustee of Pinecrest Community and Investment Trust. On June 17th, 2021, the property was conveyed to my company, Phillips Land Holdings, LLC, by deed registered at the Middlesex County Registry of Deeds, Division of Land Court, as document number 1883497. So now to the application. Our application is requesting a dimensional variance as shown on the plot plan. The house will be located 30 feet from the front setback and 15.8 feet from the right sideline. In 1995, this lot was approved as part of an open space residential development. A copy of that approval has been enclosed in your packets. The approval does not specify setbacks. The town bylaw established the setbacks, which at the time were 40 for the front, 20 for the sides. Since then, the bylaws regarding open space residential development setbacks have been revised to 30 for the front and 10 for the sides. As standard for zoning, when laws are changed for a district, all new construction is subject to these new laws. As consistent with this practice, the new setbacks should prevail, and this petition should not be required, as our plans do conform to current zoning. However, the building inspector is of a different opinion, and you can see his comments in our application. He is seeking to enforce the old setbacks. If this application is necessary, we are seeking dimensional relief from the front and right side setbacks. A literal enforcement of zoning creates substantial hardship, financial and otherwise, as a result of three unique physical characteristics of this land. The three characteristics are as follows. One, wetlands in the back of the lot. Conservation regulations stipulate a 50-foot do not disturb around the wetlands, and they're shown, it's marked in blue on the plans. This greatly limits the area of the lot that can be cleared for yard space and backyard use. Conservation has approved an order of conditions on this lot, but the order locates the house in a way where the front steps will not meet the 40-foot front yard setback requirement. And a diagram of that has also been enclosed with the packets. The second characteristic of this lot is leach fields, and those are marked in red. A house foundation cannot be located within 20 feet of the fields, which further restricts the buildable area. The third factor, ledge, is the additional factor. We took some test pits on site and we found ledge, significant ledge, where the back of the foundation is to be located. Test pits at the front of the lot didn't find any ledge. These three factors are unique to the lot and create undue hardship, not typical of most lots in the district. The houses in the neighborhood are large, and to construct a house that is consistent with the neighborhood on this atypical lot, we are asking for these setback modifications. Enforcing the setbacks of 40 and 20 creates substantial financial and usability hardships. A front yard setback of 40 would mean approximately 15 feet of backyard space can be created. This isn't very much. It eliminates the possibility of a deck, and a deck on the left side of the house near the leach fields would not be possible as well. because of restrictions on these leach fields. This greatly limits the usability of a house for a homeowner with regards to outdoor entertaining and reduces the resale value. Financial hardships are also created due to ledge. It is estimated ledge removal costs will run $30,000. The flexibility to move the house forward will help mitigate some of these costs. We are requesting the right side of the house be located 15.8 feet from the right sideline. This is required as a result of the exceedingly small building area created by the combination of wetlands, leach fields, and ledge. Per Board of Health regulations, a full basement has to be located a minimum of 20 feet from the leach fields, while a slab can be 10 feet away. We are moving the house forward and to the right to achieve the required 20-foot setback from the leach fields at the back left corner of the house, and that's marked on your plans. If we have to locate the foundation closer to these leach fields, this will add significantly to the site work costs, as well as the need to pour and compact a slab in this area of the foundation. If we have to locate in the back of the foundation, a slab in the back of the foundation, this will also limit the usability of the basement. As it stands, there will be a slab in the front left of the foundation, and we would like to have to avoid the costs, and that slab is required because of proximity to a leach field. We would like to avoid the costs and complications of having to pour a slab in both the front and the back. And also we have to keep in mind, we have to run our utilities ideally on the left side of this house. So having a slab in both locations greatly complicates connecting to underground gas, water, electricals underground there, and we have to run our septic lines. Now, this variance will create no substantial detriment to the public good. The closest point of the house to the road will be 30 feet. This will be the nosing of the front step, the bottom step. The side yard will be located 15.8 feet from the right sideline. We are requesting a 10-foot front setback variance and a 4.2-foot side setback variance. The lot is over 1.3 acres and approximately 3 times the width and over double the acreage of most lots in the area. This large size more than makes up for the few feet we are requesting. When viewed from the street, this difference will be unnoticeable. The house will be far enough from the road to not create any visibility issues and adequately buffered from neighbors. For proof there is no detriment to public good, we need look no further than the current zoning that applies to open space residential developments. The granting of a variance will not derogate from the intent and purpose of the zoning bylaws. The setbacks being enforced are no longer in existence, and we cannot derogate a bylaw that no longer exists. As stated, current zoning applicable to the open space residential development is less restrictive than what we're proposing. An approval of our variance will be more in keeping with current zoning and only serve to strengthen the existing zoning bylaws.
Okay, thank you. Questions from the board. I guess I will ask a couple just because I think I understand where we're going with this, but on the one plan in your submission, apologize, I'm looking at this on the computer there. It appears the house, is it the house next door to it? Is that approximately the same distance from the street?
The house next door to it on the right side is, I believe it is 105 Fairview. The distance from the street on that, I do not know off the top of my head, but I believe it's pretty much in standard setbacks. And actually the owner, Brian, I think is on the meeting here now. I want to say that's probably 40 feet back from the road, but I can't confirm that.
Okay, I was looking at, I wasn't sure what I was looking at. The scale wasn't quite right. And the figures that you've quoted here, the 15.8 feet to the side lot line and 30 feet to the front, outline the relief that you're seeking. That is to the furthest point, just make sure that we're not considering the wrong thing. You know, any overhangs, or you mentioned steps, so it seems like you are taking all that into consideration, but just
right. The front steps are the closest from the street, from the front,
Yep.
at that 30 distance you mentioned. And the 15.8 is going to be the closest. And I actually talked to Mr. Kefferlin, Mark, the building inspector, on that. And he said that as long as, I think, the roof overhangs are under, forget the exact amount, 16 inches or something, that the setbacks would apply to the closest point of the building. So other than maybe a roof overhang, which would be less than that 16 inches, the closest proximity of the building to that right lot line is 15.8.
okay. Yeah, all right. That's okay. Just want to be clear on that, because our we've had previous building inspectors with different interpretations on that, so we just want to make sure that anything we act on is going to work for you.
And the other thing I want to I should mention here is when you're looking at the back left of that diagram and you see the 20 feet measured, the 20 feet requirement is actually to the leach field pipe, and there's a little bit of the arrow's kind of inside that red line because it's measured from our engineer right to the actual leach field pipe, and we set that at the minimum distance. There is no wiggle room. That's as close as we can get with that full foundation.
Okay. Mark and Liz, do you have questions of the applicant?
Maybe in here and I missed it. What's the size of the foundation?
The size of the foundation, it's not listed on here. I have a plan with me that if I could give you the dimensions if you don't mind just waiting a minute.
Sure.
All right.
John, this is Brian Saxton.
Hi, Brian.
So I abut the property line here that Wendell is speaking about. You asked a question earlier because from the plans, it looks like the setbacks are similar. I have a surveyor's plan here that marked my house 42 feet from the street.
Thank you very much. Appreciate that. So that is further than this request. Gotcha.
And apologize everyone, after I zoomed in on the plan, Wendell, I can actually see there is on the plan there are some dimensions for the foundation. Okay,
I didn't, on the version I'm looking at, I don't even see the dimensions on here, but I just verified. I have them too as well. And what was the others? They're 53 across the front, and then it's 40, and then there's a slight jog to 42 in the back.
Wait, so 53 across the front, not 49? That's what's on this existing plan.
Oh, which plan is that you're looking at? No, it's not.
It's in the documents that were submitted to the town, right on the town website.
53.
Oh, so is that part of the old decision? Maybe
there was a revised application that came in later on. That could have been part of the preliminary plan that was submitted.
So the second plan with the blue and the red dashed lines.
Yes, that's
the have your measurements on. That's the new one. So across the front of this is 53 feet.
Yes.
And then is the depth the same 45 that was originally planned, or is that larger still?
No, the depth has actually shrunk. The depth is, there's a slight jog where the garage is on the back right side, and that is 42. And then the rest of it is 40. So we got a 2-foot jog on the back right, and then the back left is 40.
All right, thank you.
Liz, any questions from you?
Sorry. What is the size, the square footage of the proposed house, and what's the square footage of the houses in the neighborhood? Do you know?
The square footage of our proposed house is just at 4,000, and the average of the neighborhood, I do not know. Brian could probably speak to that, what his is. I know that they're in the neighborhood of that. They're similar.
Yeah, Wendell, this is Brian Saxton. It's approximately 3,700 is my house.
Okay.
I could get you the exact number, but it's approximately 3,700.
Okay.
All right, thank you. Any other questions from the board? Is there anyone in the audience that has questions of the applicant?
Yeah, hi. This is Thomas Ellis at 129 Fairview. My leach field abuts the proposed the home or the property. And my question is, so the leach field runs, it's on the left-hand side of his property. And I just want to confirm, he's planning on building 20 feet from that leach field? And the other question is he going to remove those trees? There's a bunch of trees on the property on the left side where that kind of, you know, they're in the same vicinity or same area of the leach fields. Is he planning on taking those trees down?
I would direct that to the applicant.
Yeah, to the applicant, yes,
yeah.
Sir. To Mr. Wendell Phillips. Yeah.
No, I appreciate you bringing it.
Okay.
Mr. Phillips, I wonder if you could.
Okay, I'm actually familiar with his leach field. His is, I think it's in the back, it's 31A, I believe, on the plan I was looking at. It's in the very back and the left of the lot. So it's furthest away. It's not near 20 feet. It's well over that. It's the very back left of the plot that we own. And as terms of clearing them, per the, I guess, agreement, there is a registry of deeds. They recorded an agreement on these leach fields, and the owners of the leach fields themselves are responsible for the actual maintenance, which would include clearing trees of the leach fields.
Okay.
So I'm just going to clear what I need for the building envelope.
Okay. Okay. All right. That's fair.
Thank you.
Thank you.
Or any further questions of the applicant?
John, this is Karen.
Yes.
I don't have a question. I just want to make a clarification. So
Okay.
Wendell has referred to the open space residential development regulations. It's not mix and match. This subdivision has a special permit under the previous cluster subdivision regulations. Entirely different animal. There is an existing special permit. That's the underlying zoning. So it's okay to represent that it's a cluster subdivision, but I have no idea whether it would comply with the overall, that is, whether it would comply with the current regulations. I agree with this assessment that it has reduced setbacks, but I don't know that the development meets the overall criteria for the current open space provisions. So if you are inclined to approve this, I would not make that finding because we have no idea what the facts on the overall subdivision are.
Mm-hmm.
I think the overall subdivision is irrelevant to the discussion. It's more specifically the lot.
Okay, you have to say that one more time for me, Karen. I'm sorry.
Yeah,
Sure.
So I was going to ask the
previous
same.
cluster provisions required a special permit, right?
The previous cluster provisions required a special permit that the whole development was built under?
The whole development was built under.
Okay, yeah.
So there is no protection under any zoning changes. the special permit is what it is. However, it's a different animal than the current, he's comparing one for one, the current open space regulations, which are by right provisions, which have different open space requirements and different dimensional requirements. So, I mean, I understand he's trying to present you with the fact that it is a cluster subdivision, but using the current regs is, I wouldn't.
Right. So this kind of exists as its own, this exists under that special permit.
Exactly.
And it's not, and just because we've since updated the open space cluster regulations for newer subdivisions, those don't automatically apply back to one lot that's in this other one.
Right.
So, okay, so I guess the issue would be, right, I mean, but then he's asking for a variance, right? You know, right. It used to be 40 and now he's asking that it be 30, right?
Right.
So,
right.
we would ask for, so it really, you're saying it should be framed as a variance as to the older open space cluster subdivision rules.
Yes.
Right, which is what it is being presented as, but
okay.
If you were to compare it to the normal zoning for that without cluster, then it would be more restrictive, right? We'd have,
yeah, the only difference is the
40
side
feet and 30 feet, I think, would be the existing, you know.
The old cluster did require the 40-foot front yard setback.
Mm-hmm.
So the only difference was the reduction from the 30 to the 20
right.
for the side yard.
On the cluster, gotcha. Yep. Thank you. Thanks for the clarification, Karen. All right. Further questions of the applicant? Is there anyone in the audience that wishes to be heard in support of this application?
John, this is Brian Saxton again. I just wanted to clarify an earlier statement. I checked the square footage of my house. It's 3,170 living space. The basement, which is unfinished, is 1,600.
Thank you.
And you asked for any comments of the audience. I would have no objection to the variance that Wendell's asking for.
Okay, thank you. Is anyone else?
Yeah, again, sorry, Thomas Ellis, 129 Fairview. My other question is, there's a retaining wall. Is the gentleman, Mr. Wendell Phillips, going to be maintaining that and keeping that, or is that going to come down?
Mr. Phillips, I wonder if you can answer that.
That's definitely going to be kept. It's going to be fixed up if there are any broken stones over there. That's necessary in order to preserve the integrity of the leach fields.
Understand. And then the driveway will be on the right-hand side of the property or the left-hand side?
The driveway will be on the right-hand side of the property.
On the right-hand side. Okay, understood.
Yes. And also, you know, all throughout during construction and all that, we're going to be very careful with your leach fields. We're going to fence them off so there will be no equipment or anything, you know, heavy equipment like an excavator or something on your leach fields. And again, your leach field is further back into the left where it's nowhere even near what the remote aspects of where construction will be occurring.
Okay, great. Yeah, I have no further questions and I have no objections either.
Okay, thank you.
Yep.
Is there anyone else in the audience that wishes to be heard either in support or opposition to this request? Okay, thank you very much. Last chance for board members. Anything else you need? If that's the case, then could we look for a motion to close the public hearing?
Make a motion to close the public hearing by the applicant Wendell T. Phillips for grant of a dimensional variance at 115 Fairview Street.
I'll second it.
Okay, it's been moved and seconded. Any further discussion? Hearing none, we'll move to a vote. All those in favor of closing the hearing on this application. John, aye. Mark?
Aye.
Liz?
Aye.
Okay, the motion carries. We will deliberate this hopefully tonight and reach a decision. Whenever we do reach that decision, it will go to the town clerk, who will prepare it and notify you. And there's then a 20-day appeal period by statute, after which, presuming there's been no appeal, the decision will take effect. So thank you very much, Mr. Phillips. Appreciate the complete and full description that you provided us.
All right, and thank you very much. I appreciate everyone's time. And if there's any questions or anything else, you can reach out to me. And I want to thank everyone.
Well, thank you. Okay. Next, we have. I'm sorry, when I had the wrong one, I dropped the agenda. But it's 16 Pearl Street appeal is the next on the thing. Is that correct, Mark? On the agenda? Yeah. Okay. So the next is a administrative appeal at 16 Pearl Street, and I think Mr. Bingham, you're going to present that to us. Is that correct?
I will. Thank you. Well, first of all, I know we didn't have a quorum the last time that we were before you, and I really appreciate the board scheduling this hearing as quickly as it did. I think that is going to be helpful to everybody. As you noted, I am counsel for JMH Trust. I have with me today two of the trustees of the trust, Megan Hammer and Brian Cheevers, who, to the extent that the board has any questions, are available to answer questions. Additionally, Joseph Marquidant of JD Marquidant, an engineer who has some connection to the property at 16 Pearl Street, is here. He can answer questions and would like to say a couple of things about his interpretation of the issue that we have before the board tonight. And if you look at the application that we filed, you'll see, at least from my presentation, that I think that the issue is a narrow one and one of interpretation of a dimensional variance that entered in September, that was granted in September of 2018. But we recognize and appreciate the discretion of the board. And it is not my intention to narrow tonight's proceeding to what I think it should be. We're here to answer your questions fully. I guess no one is more surprised that we're here tonight, quite frankly, than me. And that's because, as the board may know, I am litigation counsel for JMH in connection with an appeal that is currently in the land court on the denial of a dimensional variance. That denial was on March 2nd, 2020. And in the context of that litigation, Judge Piper of the land court indicated when faced with the issue that I have written about today, that he thought it might be a good idea if that issue was before him, before he made any determination on the appeal of the March 2nd, 2020 denial of a variance. I disagreed with him a little bit, but when a judge tells me to do something, I do it. So here we are.
Good thought.
Yes, I think it was one of the best decisions I've made. So, but I hope that today is going to be useful in that, we have a house that is now fully constructed at 16 Pearl Street. And of course, it wasn't much to me other than an address on a piece of paper that I had been writing about. But I did finally go out there when Mr. Cafferlane was nice enough to schedule a final inspection for purposes of making a determination on the CO. the ultimate determination was a denial. But what I will tell you that I saw, and I don't know if anyone from the board has had a chance to drive by, what I saw was a pretty nice house and a pretty good addition to the town of Holliston. And we're in a very difficult situation, but a situation that needs a resolution. And it's either going to be resolved by us here tonight, or it's going to be resolved by Judge Piper, which will probably result in some kind of order bringing us back to you in the future, which is when I thought that I would see you next. But I'm here earlier, and maybe that's a good thing. But in any event, I don't know how familiar everyone is with what's going on there. I know that a couple of you were among the board members who granted some of the special permit and the dimensional variance in 2018 that really is at issue here. But at the heart of this, it was our request for an inspection so that we could get a CO over, that the trustees could get a CO at 16 Pearl. That inspection took place on April 27th, and we received a denial. And I have attached the denial came by email, which we appreciate because we like speed, and we got it very quickly. Wasn't what we wanted, but at least it gave us a route to proceed. And so I've attached that as Exhibit A to my packet. And let me I'll just read what it says, just a piece of it. It says, it appears from the as-built, you do not comply with the special permit and variance issued in 2018 and the plan approved in those decisions. And it goes on to talk about an increase in the nonconformity as it pertains to the rear yard setback. So that's what we're talking about here. There were a list of items that the building inspector asked the owners of 16 Pearl Street to take care of before he would make his decision. And each one of those items, to the best of my knowledge, and I believe I'm correct, were dealt with to the satisfaction of the building inspector, which leaves us with one issue, and that is, I think, an interpretation of the word southwesterly. And I hate to be that simplistic, but I really do see it that way. And I would direct the members of the board to the decision that is most relevant here, and that is the dimensional variance attached as Exhibit G to my packet. And that's the approval on September 19th, 2018 of a dimensional variance. And the question that we have to deal with is whether or not the house, as it is cited on 16 Pearl Street, conforms with the words that the board used and have guided the owners and builders of the house on 16 Pearl Street, or whether we're outside of those bounds. And if you've had a chance to read my memo, I'll just cut to the chase. This paragraph 3 is the paragraph that speaks to the dimensional issues. And it is the paragraph that the builder is required to look at before citing a house. I will tell you that Joseph Marquidant, who was here, prepared a certified plot plan after construction. That plot plan is attached as Exhibit I, and he indicated that that the house, as cited, conforms with zoning. And what that means is it conforms with your bylaw, and it conforms with any permits and approvals that had issued in connection with the construction of this house. And so here's how I look at southwesterly. First of all, and I don't know if everyone is looking at this. It says that the dwelling shall be no closer than 8 feet to the southwesterly lot line. Well, what lot line on this property is southwesterly? Well, I know which lot line is the southwesterly lot line. It is the rear lot line. And I was quite frankly very surprised when I heard that this was actually the basis for the positions that the town was taking with respect to the siting of the house. Because it appears, at least in the litigation that we're still engaged in, that that southwesterly lot line, that word southwesterly is being interpreted as the left side yard lot line. Mm-hmm. And I'm an attorney, so when I tell you my interpretation of southwesterly on a plan, it doesn't mean much. And that's why I have Mr. Marquardant here. And so we'll give him an opportunity to either answer your questions. I can run him through, his interpretation here, whatever works best for you. But when I look at paragraph 3, something strikes me immediately. And that is that there's only one way to read this, and to read it in a way so that it accounts for all four. There are 4 lot lines on this particular property. There's only one way to read it and account for all 4 lot lines. And the front is easy because the front says, shall not, let me see. The dwelling shall be no closer than 6 feet to the front lot line. Well, we have no question about that. But before I go on and talk about the other 3 lot lines, I do want to say one thing. This was the trigger to the problems that we're having today, because a prior building inspector, when looking at the plan that had been utilized as part of the approval, and that plan was a septic plan, which is attached as Exhibit H, noticed that that plan didn't contemplate stairs, but that the house as situated on the plan was 6 feet from the lot line without the stairs drawn in. And the words that he used are not 1,000% clear to me right now, but the inference that was being made is that the house needed to be moved back. And when faced with that, the builder looked to this decision to decide what it is that he had to do, and I think correctly determined that he had some leeway to move this house because of this interpretation of southwesterly. But that's how we get here. Quite frankly, I don't read your bylaws requiring as uncovered stairs being counted toward the front, but that's beside the point because they didn't go that way. Now, what other lot lines are covered by paragraph 3, are addressed by the words of paragraph 3? And this paragraph 3 says this shall not encroach into the required side yard setback. Well, that covers both side yard setbacks. And there's only one more description of a dimension, and that is 8 feet to the southwesterly lot line. Well, to read 8 feet to the southwesterly lot line as the left side yard would cause some significant interpretation problems, because it would be possible for one to comply with the 8-foot requirement and still be in violation of the side yard setback as it under the existing conditions of the prior house. So you basically have 2 descriptions of what can happen on the left-hand side, and I don't think that interpretation is one that that meets our general manner of construction of statutes, decisions, and the like. That there really is only one, that the intent was that it be that southwesterly is the rear, and that the moving of the house backward by 3 feet did not violate that requirement, because we've got, I believe, 19 feet as the house currently stands. So, that is that's the legal issue, and quite frankly, the issue that I was talking at some length with Judge Piper about, and the one that he wants before him if he's going to make a decision. So I put that out for you today, and I am just quite hopeful that you will see that this interpretation is not an invention. It is the one that is most logical, and quite frankly, in fairness to the builder, one that he had the right to rely on, whether there's ambiguity in it or not.
Can I ask a question? I'm sorry.
Of course, I like to be interrupted because it stops me from talking and I get to restart again. So please do.
So what would help, I would think, in terms of if we're talking about intent, and I think since the builder was the applicant, did you include the builder's application for the variance in this paperwork? Because, you know, in his original, and the variance that was denied, I think it was clear, from what I remember, it was clear what his interpretation was, and I don't think it's the one that you're mentioning now. I mean, now you're going back and saying, oh, he saw this decision, it was ambiguous, he thought he could move it back under the wording of this old special permit. But I don't know if that was ever conveyed in any previous hearing or in any of the paperwork that was submitted before.
So the direct answer to your question is no, I did not submit that application, but I will. Can you
supplement this record with it? Can you submit it and supplement it? Could it be helpful to see?
Let me see if I can help with that issue, and then if you feel that you need it, we could talk about supplementing the record. And but what I'm going to tell you, what the application does not help with the answer. I have looked at the application, and it really doesn't address the issue that you're thinking about. At least it didn't for me. I know what the problem was here, and the problem was that the only, you know, the hearings back in September of 2018, it was a one-day hearing, and both applications were granted special permit and the dimensional variance. But what was missing from the record were an existing conditions plot plan or a proposed structure plot. None of those things were there. So unfortunately, the record is silent on those issues. And the only thing that would be helpful was a plan, and that was the septic plan that the decisions relied on, which is why I submitted the septic plan to you. That's exhibit H. But I'm representing to you that I have 100% confidence that there will be no assistance to you from looking at those applications. Did that help? I mean, I
just think I don't know what's going to happen after this hearing, but I would just think if it goes back up, you want a complete record, you know, before the land court. I mean, I'm not saying it's going to go back up, but to me, if a lot of your argument is on, you know, intent and reasonable interpretation, then indicators of an applicant's intent is in the language of a lot of these applications. So I just think that it just creates a more robust and complete record if you're talking about, you know, what people thought was happening at the time. And it would be helpful, well, for me, because I wasn't there in 2018, to get a sense of that.
Neil,
yes.
Can I jump in here for a quick second, or
sure.
Brian? Hi, this is Brian Cheever. I'm one of the trustees of JMH Trust. So, when in the reasoning behind sliding the house back was the building inspector, before he issued a permit, asked us to get an engineered plan that was stamped, which we provided, showing the house exactly where it is right now. And when we looked through all the decisions and the paperwork at the time, it's a professional engineer that did this, and they would not put a house in a spot that is illegal. They had asked a question of the building inspector. He had inferred certain things. We looked at all the paperwork. We looked at the southwesterly side, and we determined that the house could be slid back. We were under and we did receive a permit with that stamped plan, which was stamped in late November by GLM Engineering. And the building inspector did have that. He had specifically requested that before he gave us a building permit, which is why we were so surprised when he came back to say that it's not lining up with the original plan. So there was no.
Go ahead, Brian.
No, I said that's, you know, when we looked at the decision, we saw the 6 feet from the front. We saw that, you know, southwesterly it said 8 feet. We were well within the 8 feet because when we slid it back for the steps, it became 19 feet instead of the original 22. So that's, and like I said, it was all engineered it was through a professional engineering company, and we just assumed everything was fine. The building inspector gave us a permit based off of that. And we were, you know, when this came about, he made it seem like it was just a formality to go back before the board and everything would be fine.
And the plans that Brian is speaking of are attached to our packet as Exhibit E and Exhibit D. Exhibit E is the specific one that he's talking about, which is the proposed, which shows the proposed dwelling. That's the one you're talking about, right, Brian? The proposed dwelling, it's dated November 30th, 2018. Is that what you're talking about, Brian? GLM.
Got my stuff screwed up here.
So Brian,
that's exactly what I was talking about. Yes.
Yes. Okay. So that's Exhibit D is the pre-construction existing conditions, and Exhibit E is the proposed dwelling. Both documents certified by GLM.
Yeah, and so I have a question. So I recall, and Brian and Megan can certainly help me out here, and Mr. Chairman, you probably can as well. So Attorney Bingham, you said that Exhibit I is the existing true plot plan. Is that correct?
Exhibit I is a later certified plot plan of the exact location of the house as it sits there today.
Okay, with the exception, of course, if you look in Exhibit H of the bulkhead, because they turned the bulkhead 90 degrees, and wasn't that the whole rub originally?
No
because
bulkhead.
they turned it 90
there's no bulkhead issue.
There's no bulkhead issue.
No, that was the house across the street you're thinking about.
Okay. Yeah, as Mark, as I recall, maybe I can ask a question. Same with this particular application, was the original siting cited, and I understand the reference to the southwesterly line causing the confusion is, but as I recall from the original application, there was seeking relief on the side and the front because they both needed it. There was no requirement for relief from the back, which would be I guess would be the southwesterly line as you're defining it, Attorney Bingham. And then when the house, because the issue in the front of the house was discovered that it didn't allow for the stairs, the whole structure was pushed back, which created a new need for relief in the rear of the house, and which is what the previous application for another variance that was later denied came in for. Am I misstating that?
Who are you at? You're asking.
Well, I'm talking about the ninth. I believe what was at issue once the building was built was that while there was the side lot line, which was originally set at that, was it 8.2 feet or was okay, and the front was now okay, but in relocating the structure from what had originally been thought because of the need for more space in the front due to the stairs, it now pushed into the rear setback, which under the original plan was never an issue because there was no need for relief there.
Well, I think we talked about the reason we slid it back was because when the engineers read through the plan and we all looked at it, we saw that the southwesterly side said 8 feet, and that's the rear is the southwesterly side. So they drew the plan up, sliding it back that 3 feet, which is what the building inspector inferred he wanted done. He counts the steps, so it had to be adjusted.
If that's the case, I mean, I guess I question that because it's different than my memory, although I won't go to say, if that's the case, then aren't you in violation of the setbacks on the southeast? Is that
easterly side?
Yeah, I mean, as I understood it, the original one, there was need for relief on 2 of the 4 sides, but when the building got relocated, there became now need for relief on 3 of the 4 sides.
Can someone share this on the screen, the proposed, so we can all just, it's just really helpful for me to actually look at it. This is the GLM proposed from November 30th, 2018. It shows, you know, an 18.2 side, a 19 feet in the rear, and then using this, we could see, you know, it looks like the dwelling didn't go into the 8.2 section. It went into the 19.
It went from 20.
Well, it's worth looking at Exhibit D, the exhibit before that, which is the existing conditions, and you'll see that the closest point to the southeasterly lot line to the left side is 6.9 feet, and then another portion of it was 7.4 feet, and the goal of the builder here was to ensure that they didn't encroach into that, because that would definitely have been a violation of this, and it doesn't. It's now 8.2 feet, so further away than it previously had been. So conforming with the, this is Exhibit D.
And that was the former house as built.
That's the former house. And then we look at this.
But the other special permit was based on the proposed, right, from November 30th, 2018. It wasn't based on the former house plan, right?
Well, if we look to the words, it was in this respect. It so the 2018 variance decision speaks to what can be done with respect to side yard setbacks, and it just says shall not encroach into the required side yard setback any further than the existing dwelling. So that was the purpose of this plot plan, which is attached as Exhibit D, was just to figure out where that existing house was and to make sure that the new house didn't get any closer to that lot line, which it does not.
So you're saying the existing house, the lot line was 6.9 feet away, and and it was built at 8.2, and so.
That being said, could I ask why was your interpretation then that there would be a restriction on the southwesterly of 8 feet when your plan showed it at 22 feet? Why, you know, I think I fully understand your concerns about southwesterly versus southeasterly, but to me, I think that's the intent seems pretty clear that they were talking about that side lot line, not the rear, and certainly didn't want the building to come 15 feet closer to the rear when there's specifically said that
right.
no greater.
So So how that ended up 8, I don't know. That was, but what I will tell you is this, is that when, you know, I'm not a judge, I'm just a lawyer, and a judge will ultimately tell us what the law is if we're forced to go back to see a judge. But that's where intent would come in. But intent really only comes in if there's ambiguity in the interpretation of the document itself. And with respect to that rear lot line, there's nothing ambiguous about it. It's, in fact, it's very clear that it's 8 feet. Whether you intended it to be 22 feet and it says 8, I just don't know the answer to that. But it, you know, I can only assume, I can only make assumptions. Never a good idea, but you know, one is to potentially give some wiggle room to the builder. I don't know, but what I do know is that you know, it would always be my position that the issues of intent would not come into play here because of the clarity of the words that were used for purposes of identifying what we can do within that 8 foot, within that toward that rear setback lot line. So I think one thing I would just like to be sure of is just to be certain that the record on this southwesterly interpretation is satisfactory to you. Not that you agree with it, but that at least my presentation of it is. And I have Joe Marquidant here, who was the individual who prepared the certified plot plan exhibit I, which shows the house as it currently sits. And I know that his words are probably more meaningful than mine, but I just wanted to lay out how I interpret things based on in part what he had to say. And would it be helpful to hear from him as well, or do you feel this is addressed?
Well, let me ask the other board members. I believe I understand your argument to this, but I don't want to speak for my colleagues. So Mark and Liz, would you like to hear from the engineer on that?
No, I'm fine. Other than I just want to, in fact, clarify that the bulkhead does stick out perpendicular to the house. It's so that exhibit I is incorrect because it sticks out further than the line. And as long as it's out, you know, I think it's measured at 8'1". That's fine. I'm looking at it on Google Maps and it does in fact stick out further than the house. So just exhibit I is incorrect. But as long as you are 8'1", as in exhibit H, that's fine, but hopefully you're not encroaching on that 8 foot side setback. Anyway, exhibit I is incorrect.
In that case, why don't we hear from an engineer and speak to that, because I don't want any ambiguity.
Evening, folks.
Are you there? Yes.
Evening, folks. Joe Marquidant here. I'm not privy to the particular filing by Attorney Bingham. I'm not sure exactly what you're referring to with regard to item I. We did prepare a plot plan. September 19th was the original date, revised to December 6th of 2019. And that includes the existing bulkhead with a dimension to that side lot line of 8.1 feet. So if you're referring to the plot plan we prepared, that's the number that to the offset to that boundary line in question.
Maybe that's the discrepancy, because the plan that we're looking at is July 30th, 2018. Not, what'd you say, December 20th?
That one was submitted with the original.
Oh, I see. Can I clarify?
please.
Yeah. So
Yeah.
there are three plot plans here. Exhibit D is pre-construction existing conditions plot plan, the prior house. Exhibit E is a 20, and that was a November 30th, 2018 plot plan. Another November 30th, 2018 plot plan is attached as Exhibit E, and that shows the proposed new dwelling before construction. But then the plan that Mr. Marquardt is talking about is Exhibit I, and that is the third plot plan, a certified plot plan dated, Joe, September 10th, 2019. So that's the one that is showing the bulkhead at 8.1 feet. And the only thing that I'll note is that if you compare that to the existing conditions plot plan D, you'll see that that's still further away from that southeasterly lot line by half a foot than the old house. The bulkhead.
So, again, dimensionally, I think you're fine, but the statement that Exhibit I is the be-all, end-all plot plan is incorrect because
maybe I'm not.
It's not representing the bulkhead correctly. That sticks out further than the house.
Okay, so I hear what you're saying, and I just misunderstood. I'm not disregarding what you say, and I just don't know the answer to it. So I guess I would ask Joe Marquardt if he has any information beyond what his plan says. But
and then Attorney Bingham, the other thing I would say is this, and also on Exhibit I. So I just think the wrong plan was filed because it still says that the back, the rear setback is 22 feet in Exhibit I.
We
if you look at the measurement.
What's the date of the plan for Exhibit I for you?
It's pre-construction, I believe.
July 30th.
I see the same stamp that you see, September 16th, I think it is, 2019.
Okay, so there is some...
And down, if I may, the bottom right, there's a revision box.
So I think I know what's going on. And that is that I think the plans are mixed up in the versions that you got, and that when we're referring to one, I am misleading you accidentally because I'm referring you back to a 2018 plan. What I'd ask is, one, that you forgive me for that if that was on my account, but two, that regardless of what plan we look at, hopefully you have all three, that we look at one that is dated September 10th, 2019, and it's stamped by Joseph Marquardt as opposed to GLM.
All right, and that's just it. Yeah, so the exhibits are swapped. So H is in fact the real plot plan.
Okay.
My apologies.
Okay.
Could I ask another question on that? The original decision references the record plan prepared by Civilized Solutions entitled Septic System Construction, dated July 30th and revised through September 19th, 2018. Do we have that?
That's Exhibit H, I hope. I make no promises now because of what just happened, but I assure you the septic plan is attached.
Thank you. That is. All right.
Yeah, here's the septic plan. And this, the septic plan was what was referenced in the decision, right?
That's correct.
Yes.
All right, so let me just.
Okay. Are there other questions? I think we sort of got, well, let me ask you, Attorney Bingham, is there anything else that you wanted to present as we kind of interrupted you? And
I did not feel, I didn't feel interrupted, but thank you for that. I have presented what I wanted to present. I say again that I'm here to answer any of your questions, of course, but otherwise, I think that our presentation is complete.
Okay, thank you. Mark and Liz, I know we've had some questions, but do you have some further questions of the applicant? And then I've got some questions of the.
Not for me.
Some others. Okay, Mark Kefferline, the building inspector, is here, and I think since this is a request for an appeal of his decision, I'd like to ask you, Mark, to maybe weigh in on what went into your decision and you know, fill us in on where you.
Well, it's pretty simple. I mean, you guys, everyone's talking about words, but picture says 1,000 words. The plan approved and the as-built don't line up. So the plan approved, whether it's southwesterly, east-westerly, I don't care what line it is, if the building isn't in the location of the approved plan, then it's not approved.
Okay.
So it's simple. No, am I wrong on that?
Well, I think we're in the same place, but can you describe?
And you're talking about all these plans.
The approved plan is Exhibit H, correct?
I don't have the packet in front of me, so
if the plan approved is what you're saying, that's not the right plan, then the plan approved showed us not having any front steps, so we should have been allowed to put the front steps 3 feet closer to the road.
So hold on, Brian, for 1 second. If I could just, Mark, I didn't want to interrupt you, but can I respond to that, or did you?
Well, before we do, let me just do this, make sure I understand. When you reference the plan approved, Mark, you're talking about approved in the variance or for the construction?
The decision.
Okay, thank you. Which in this case, if I'm not mistaken, from the earlier question I asked, would be Exhibit H, the septic plan by what's their name? Something management. Dated July and through September 19th.
Yeah, is Daddy okay?
That's what you're referring to, and in this case.
But you have to, I mean, you have to show them to me. I mean.
Yeah, all right.
The approved plan is the approved plan.
I'm looking at a different computer than this, so I can't put it up.
The approved plan, the approved placement of the house was turned into the building inspector in November. We got a building permit in January of 19. It was turned in November of 18. And it had the exact place of where the house is today on it. He approved that and gave us a building permit based on that.
And we have to look, now we can look back to the decision itself, because with the approval in 2018, the board did not have building plans. And paragraph 4 contemplated that building plans would be prepared after the approval. and that they would be substantially in compliance with the materials viewed at the public hearing. There was every expectation that and quite frankly, that the lot lines would be marked, you know, all sorts of things were going to happen post-approval, and those things happened. And
yeah, but those are building plans, not plot plans. You can't do a plot plan post-approval because you're approving zoning.
No, I'm not talking, no, the building plans. It says final
well, the building
plan.
plans have nothing to do with the zoning of the.
There was no plot plan at the approval stage. None.
Well, there was, the decision refers to the record plan, which is that and specifically defines it as that septic system plan. So I would have to believe that that was what the board was relying on to determine their dimensions and the location of the house.
That's why the application itself would be helpful,
right,
because we probably relied on what was submitted with the application.
Yes, agreed.
So, and Mr. Carfeline, how did the final location of the house or the final location differ from that record plan? That's what I just want to be clear.
It was 22 feet in the rear to 19 feet in the rear. And it remained 8 feet on the side, which was the 8 feet in the decision, which I believe the board intended was 8 feet, no closer than 8 feet on the side.
Okay.
And then, you know, again, as Brian said, I don't need to speak for him, but the house was not built in a vacuum. The plans were submitted to the then building inspector for approval, for a determination as to whether or not those plans were substantially in compliance with what had been submitted. And the then building inspector clearly, correctly determined that they were, in our view.
Thank you. Okay.
Well, I can't speak for the prior building inspector. I don't know. But I do know anything attached to the structure is the structure.
Mr. Chairman, I hate to interrupt, but I feel it necessary to just make a comment. Counsel for the applicant is referencing a timeline, but not the actual documents because they haven't been provided to the board. There is a building jacket that shows, in fact, these applications and correspondence between your prior building inspector and the applicant. Including what was submitted and what was still being asked for during this timeline. So Mr. Canny is not here to defend himself, but I think that record would speak for itself. And I'd invite you to look at it if there's any question in your mind as to whether or not Mr. Canny actually approved this change before a building permit was issued.
Okay, thank you, Attorney Winter.
We have an email from Mr. Canny with what he wanted before he would issue a building permit, and we provided him with all that information. He sat down with our architect and sat with her for over an hour one day to go over a couple of things, and we followed up. We gave him everything he wanted, and he gave us a building permit in January of 19. The original email was late October of 2018. He had 5 or 6 requests that he wanted. We took care of all those, including the placement of the house, the as-built that was done by GLM, which is a stamped drawing, which we turned in, and he gave us the permit in January of 2019. So we assumed we had everything was all set.
And once again, I hate to reiterate this point, but you know, your computer systems and your building permit records show these conversations, and there's notes made, including as built shows house does not comply with rear yard setback, 1029-19, advised to proceed at own risk, needs variance. So the sequence is It's not what's reflected in the actual record. Framing plans were.
I can provide the email. I can provide a 2018 email. That's no problem. I think I have.
I think those records would in fact educate the board quite a bit on the sequence of events.
I agree.
Honestly, I think we at our last, when we denied this, I think this was discussed, and maybe we didn't make it an explicit factual finding, but I believe the factual finding was that the applicant was quite aware of the problem with the stairs and chose to move the house back prior to coming to get a variance, and that's why we weren't able to find a hardship. So
we did not choose to move them back. The house was moved back because we have a stamped as-built before we received a building permit where the house was located. We put the house exactly where the engineers had stamped their drawing, and we turned it into the building department. We did not move it back on our own.
That was, I mean, we'll look at it again. I'm happy to look at it again. But.
If that's the case, then it would be 22 feet off the rear lot line. And I specifically remember asking Brian that question during a public hearing of why, you've built a lot of houses and are very experienced at this. Why did you just choose to move the house back and build it without coming back for approval? So
we didn't think we needed approval because we had turned in we had a drawing turned in that showed exactly, we placed the house exactly where we have the stamped GLM engineering position of the house. That's where the house is built.
The variance, as I read it, but
so we need to back up just a little bit, and here's why. Because there was really nothing wrong with the timeline that we were providing you. Town council has just jumped ahead to post-construction and talked about an email from the building inspector, and there's nothing wrong with that. However, it was build at your own risk, and that's what we did. And apparently, and now we have a denial from Mr. Cafferlane. Okay, that's the issue that we're dealing with today. It doesn't matter what he said, whether that was his view. In my view, he was incorrect as a matter of law when he took that position, as Mr. Cafferlane is as well in his decision, with all due respect. So reviewing all of those records, it would be interesting, but it really would just bring us right back to the exact same discussion, and not even a variation of the discussion, the exact same discussion, which is this decision that you built and relied upon, that you allowed you to go back 8 feet. That's our interpretation. And it either did or it didn't. And I think that we need to stay focused on the words of this decision as we go forward. And it's very easy for lawyers to go back and forth, particularly when we're engaged in litigation, and because there are positions that we could take and try to confuse this issue. But I think that that's all that just happened right here. But it brings us back full circle, that instead of here appealing a decision by the prior building inspector, we're here to appeal the exact same final decision by the current building inspector. Nothing that it changed, those words changed nothing.
I don't think you can look at the decision and the language of this decision outside of the application itself and the documents that the decision itself references. I think that by the mere fact that it's referencing other documents, it's incorporating those documents into the decision. I just think that, it's just confusing to me why you wouldn't want the whole record to be looked at, because you're trying to say that if you take this one paragraph out of a decision, it means there was no need for a variance. And that's just not, that's not how the decision was created to begin with. I don't know. You could be perfectly right. I have no idea, but I'm not going to look at a third paragraph of a decision and make a very four corners, legal term decision based on that language. I think that it's just not fair to the process. To understand if he interpreted that correctly or not. I think you just need to see a little more. That's all. I mean, I don't know if he did or didn't.
I agree. I would agree with you if the words were ambiguous. Okay, if we were dealing with if I was doing a zoning opinion, for instance, and I had no connection to this, the thing that I would look to are your zoning bylaws, general laws of Massachusetts, and then I would look to special permits and other things that are of record, and I would make a determination about what I could do. I would not be required to go back and figure out what the intent of the words were, unless there was something wrong with it. If the words were ambiguous, you know, maybe, but they really are not ambiguous here. And I think that is the reason why you should allow the application and direct Mr. Cafferlang to issue a CO. And of course, the other benefit of that is that if that were to happen, that, you know, the litigation that I am representing the applicant in would be resolved. And you know, if we're wrong and you're confident of that, then you have to follow your conscience. And I get it, and I appreciate that. But I truly believe that my clients acted in a very, very reasonable way, and at all times were trying to do their best to conform to the zoning bylaw and to appease the building inspectors at various times, which is what you have to do. And they did it all in compliance with the clear words of this decision, in my view. I guess that was, you know, if I was going to come up with a close, that is my close right there. That, you know, these are the words. Please apply them in a way that is fair, and please think about what's going on. I mean, this is not good for anyone. I don't know what the solution is. Let's say we're wrong. Let's just say we're completely wrong. What is the solution? To what, tear down a house? I just don't know what the solution is here. And we have a problem, and it's not going to go away if we don't resolve it tonight. And I just would hate to come back before you again after some decision by a judge telling us to do something, to do the thing that we could do right, that could be done right now. But you have a beautiful house, a beautiful addition to the town of Holliston. The only thing you don't have is a young family who's moved in that can begin contributing. And instead we have I don't know how the taxing is working over there, but right now I think that we have something that is valued at probably less than a lot if the potential buyers think they have to tear the thing down. But in fact, we have something beautiful there. And, you know, in my view, it's time for someone to move in and for this to be put behind us. I think it's best for the town, it's best for this board, and it is most certainly best for my client. I do not deny that.
Thank you. Is there anyone else in the audience that has questions of the applicant or other parties to this, or anybody else on the board? Okay. I would like to see the rest of the documentation, the original request. I note that I was not on that decision, so apparently I missed that meeting. I remember the subsequent stuff. I remember reading this case at the time, but I would like to see the original application, because I think that speaks to some of the original request and speaks to, I think there is some.
Ridiculous. We spent 3 hours talking about no decision.
Right.
I'm sorry, we've got somebody speaking. You might want to mute yourself.
Yeah, you might want to mute yourself.
I know, but I want to read it.
There we go.
I don't know who we hear talking in the background, but
I did, yes. We've asked them to mute themselves, they did. In any case, I think to me, there is ambiguity in that decision itself, that because of the reference to the lines and recognizing the board and their normal course in that kind of decision, I do have, and in order to fully understand that, I'd like to see the building jack in the original decision, the original application, and the relief that was sought for this, because I think what was granted was consistent with what was sought, but I think maybe the language left some ambiguity. So Karen, is it possible for us to get that copies of that information to review? Okay, I'll presume
yes, it is, but I would offer perhaps a question to Attorney Winter, which is that the application was stamped in on May 18th, and I would hate for you to not act in a timely fashion.
I see. What is our time to do that?
What is the timeline?
I'm not sure. Brian, do you happen to know what the?
Yeah, I mean, if I may.
Yes.
I mean, if it was May 18th, you're only 45 days into your clock. Is that correct?
That would sound right.
May to June.
Yep, sounds right. Close enough.
So within the 100 days, you could, I'm sure, notwithstanding the holiday.
Oh yeah, no, I think we have a pretty good idea. We just don't want to make.
Yeah.
I don't at least want to make a deliberation and a decision when I think there's information that's pertinent to it, that's part of the record. So I think we could do it expediently, but I agree with you, Karen. We don't want to muddy it further. And I also recognize the time that the applicant is under and having to deal with the related legal matter that's dependent on this. So I don't want to delay it further, but I'd like to get that stuff, if we could get it in the next couple of days.
Well, I am, can you hear me?
Yes.
This is Neil Bingham. Yes. I'm a little bit torn. As you know, we are soon to report back to Judge Piper about how things are going. We've been continued once, and I just tried, as we were here, to call my clients to talk to them about what I see as the result of this, and that is, quite frankly, I don't think that you can, or I don't know, but I hesitate to have this go to another meeting for the things that you're requesting. Not because I am afraid of them, I am not, but quite the opposite, and that is that they are going to provide no relevant information to you, and that we will have wasted, I don't know how many more days, and then if we don't get a quorum next time. So in part, I want to have this thing proceed so that we can get into the land court if we're denied, and we can move on. But I then put the brakes on as quickly as I can, because I know that you're going to make a decision that you think is fair, and that doesn't mean it's my client's decision, but one that you think is fair and reasonable. And I want you to have that information. However, I hesitate to go to another meeting, and I would request that you make a determination on the current record before you. That's my 2 cents.
All right, thank you.
Brian and Megan, is that okay with you? I was speaking without having been able to consult you, which I don't like to do over Zoom, but here we go.
No, that's fine. Megan doesn't have internet. She's off. She's lost with the lightning storm. She's lost contact here. So.
Oh, I see. All right. So you agree with what I just said?
Yes, I do. Yeah, I trust your thought. Yeah.
Thank you. All right.
Okay, thank you.
I mean, we really would like to get it move forward. You know, I agree with what you said. I feel like, you know, we're ready to get a nice family in to start living in Holliston. I mean, you know, it's gone on for a long time. We feel like we built a nice home. We did the right thing, and you know, it's been a long time that we've been suffering through and holding out on this. So you know, there aren't many options right now.
Okay, thank you.
Thank you, Brian.
Liz and Mark, are you prepared? I guess. Well,
I'm not prepared to make a decision tonight.
Yeah.
I mean,
Well,
right? I'm supposed to look at the material and try to decide if he made the right decision or not.
mm-hmm.
I feel like I can't do that without understanding more fully the application. So, you know, no, I don't.
Okay.
You know, I want to make sure that I mean, I do approve it or deny it without fully understanding it. I don't think that's our job.
No, certainly. I mean, so given that I don't think we can introduce new stuff if we close the hearing, we would have to continue.
John, what are we looking at for a continuance? So is it the next meeting? Can we get the information to you so quickly that it can be done without waiting a month to 6 weeks or whatever the next meeting might be? I mean,
well, I was just going to ask these guys their availability.
Could we meet? I mean, if this is what you do, obviously this is your. I'm just visiting. This is correct. Yeah. We do what you do, what you decide you're going to do. But I mean, is there any chance? And we need the three of you, and we can't have two of you and someone else. I mean, that's right. We're in a difficult situation.
I mean, I'm willing to come back on July 14th. I am on vacation the 19th to the end of until the early August. So, I mean, I'm happy to do this as quickly as possible, so it creates the least amount of trouble. But
as am I, but I'm not available on Wednesday the 14th. 13th.
13th, yeah. Let's.
Tuesday the 13th works if that's okay with everyone.
You know, I'm going to leave our view of an objection to this to my client, but I'm going to support it 1,000%. And whether we would object to not closing the hearing, but I think I've heard.
You know, I think we've tried to accommodate that, Mr. Bingham, but certainly, as you said, that really is our decision. And I think if the board members aren't prepared to render a decision due to lack of information, I mean, I think it'd be in your best interest for us to get that before we do it.
Okay. Can I? Yeah. So, all right. So you have decided that you're going to continue the hearing to another date, and now we're just talking about a date. Is that a fair statement?
I think that's what the consensus is.
Is there any way we could do it next week? I
think are you around, Liz? I think we can get the information quickly and review it. I don't know. I could do it next week, Mark or Liz, if either of those.
I'm around. Yep. Just look.
And if we do, I'd like to limit the agenda to this issue, only this issue. So
I can do Tuesday. I cannot do Wednesday or Thursday.
So that would be what, the 6th?
Yes. Does that work for everyone?
You give me a day, I'm gonna be there. I'll find it.
I can make it work. Karen, can we get that information? This is the 4th of July weekend coming up. Can we get the information in the next day or two?
Sure.
Okay. And I think what we're looking for is the information in the building jacket, the original variance application that was approved. We have the decision. Is there anything else, Mark and Liz, that you can think of?
Just
I would like
any plans that were submitted.
Right, right.
I would like the actual application and plans that were submitted that we denied too.
Oh, okay, yeah, on the, okay, because there is
The
reference.
2020. I have everything, and I'll tell you I can have it to you very quickly, and by that I mean tomorrow.
Okay.
So you want the entire 2020 variance package with any plans that were attached, applications, supporting memorandum, or other evidence submitted at the and we have a list of that in the decision.
Okay.
So I can get that
one
for
I'm
you.
sure you have.
And the 2018.
And the 2018.
Yeah, all the way back. Yep.
Application.
And the 2018.
Plans,
I have all of that.
The root of the confusion.
And then also the jacket information, right? I guess, Karen, you can get us that, right? In terms of the back and forth.
Yeah, I'd actually.
Yeah. And I think the one thing that we never did see was because it was after our involvement, was the building plans that were approved. I think we should probably, I don't think we need to see the full set of plans. But
well, I'm just thinking of one thing out loud, and maybe it's this, is that maybe I should not be involved. I mean, this is all available to your town council has all of these documents and gave them to me, but rather than, I don't want to make a mistake myself and then have this conversation occur next week. Well,
I was going to suggest that anything you do it through Karen, so that she can supplement anything that is lacking. But yeah, that's quite all right. I understand your position.
Yeah, I'm not trying to be unhelpful.
I think
it's actually probably more helpful.
And we shouldn't be relying on you for it. But in fact, more importantly, what's in our record is probably we should be working from.
Okay.
So
all right.
We'll get those. In that case, could I have a motion then to continue this until talking about July the 6th at 7? Does that make sense, or is that time okay?
Yeah.
Yeah. Go ahead, Liz.
I'll make a motion to continue the public hearing of the administrative appeal regarding 16 Pearl Street until Tuesday, July 6th at approximately 7 p.m.
Second.
Moved and seconded. Further discussion? Hearing none, we'll go to a vote. All those in favor of continuing the hearing, John, aye. Liz?
Aye.
Mark?
Aye.
Okay, thank you. Thank you, Attorney Bingham, and we will train as.
I just want to say thanks to the board for putting it together so quick for next week. They really appreciate that.
Well, we're not trying to string this out anymore than we want to.
No, we appreciate
the right information and
doing it on so quick. So that's very appreciative. So thank you.
Thank you very much.
Thank you very much, all. Good night.
Okay, take care. All right. So for our other applicants, sorry we didn't get to your stuff quite on the time frame of the agenda, but I think the next one is hearing for a variance application at 0 Fairview Lane. Is that what's next? No, I'm sorry, we did that. I got the wrong one. 27 Dean Road.
27 Dean.
Dimensional variance. I beg your pardon. I'm looking at the wrong piece of paper. We have I think I've seen your name all. Ms. Buckner, you're going to present that one for us?
That's me. I'm Jen Buckner. So I live here at 27 Dean Road, and I am requesting a dimensional variance to go along with the plot plans that I submitted to you. So basically, I live in a relatively small house on a relatively small lot, and the catch is it's not a corner lot, but the road curves around my house, making it the plot line's a little weird and curvy, making it a very difficult place to build a house on, or to expand in a house on. So if you're looking at the plot plan, there's a small addition that's going on to the right-hand side, and I want to talk about that side first. So that side, my existing house is set back 26.8 feet. The addition would only be 25.2. So it's only a difference of about 1.5 feet. So we're not making the sight line as you go around that corner on Dean Road. We're leaving that sight line exactly as it is. But again, it's just because of the way the road curves. And then on the other side, it's simply the deck is going over by about 1 foot on that side, over the sideline on that side. So we're just asking for a little bit of leeway to put those two pieces in place. Is there any questions that I can answer for you?
Yeah, let's just make sure we've got the looking at and your application and your plan. If we do, you don't have a lot of opportunity going backwards due to the septic system and
correct
anywhere else because of the size and shape of the lot and the unique characteristic of the being on the curve and having then front setbacks on several sides of the house.
Exactly.
So let's talk about the small one on the right. Just make sure that we're correct. That is not extending any farther forward, but it is going closer to what is still the front, but it's the side.
I call that the right side of my house, even though the plot line is a front plot line. Yes, and that's where it was so confusing when I was trying to figure this out, because it is front setback, even though it's the side of my house.
I get you. Yeah.
But yeah, I'm not bringing it forward anymore. I'm just bringing it right.
Mm-hmm. And because of the setting it back from the front, the actual increase in non-conformance is 3 feet, roughly 3.5 feet. Gotcha.
Yep.
And now on the left side, the addition, I'm trying to.
So I have an existing porch already there. Mm-hmm. That is actually going to be ripped down, and a new living space as well as a deck is going to be put over there. And it's just a little bit of the deck has to go over the side setback, simply because I can't go pretty much anywhere else, again, because of the septic that sits right there.
Mm-hmm. And the addition in the front, that doesn't require, the enclosed addition doesn't require any relief, is that?
Correct. It's
that's
just
all within your setbacks. It's the edge of the deck.
Correct.
Okay. And it would appear, given the existing structure, that if you were to try to maintain that along the setback, you would be too skinny to be functional.
Exactly, because again, because it's the way the lines kind of merge in a little bit, it's a weirdly shaped lot to build a house on, and definitely to expand a house.
And because of where it was built initially.
Exactly, and where my septic is, yes.
Of movement. Okay, I think I understand. Mark and Liz, any questions of the applicant about this?
None for me, John. If you scroll down in the package and see all the renderings, it's
yeah, it's pretty
very helpful.
Yep.
I don't have any questions.
Okay, yeah, clearly you're sticking with your existing or consistent architectural and materials palette, which is something we would require anyway. But
yeah, we took a lot of care in preparing this to make sure that it would still look like my house and it would still fit with the neighborhood. I'm currently one of the smaller houses of my immediate neighbors. And even with the addition, I'm still going to be right in with them, if not a little bit smaller still. I'm not going out of control for what is my immediate surroundings. I'm trying to keep it in tone with my neighbors.
Okay. Yeah, I think I understand it and makes sense. Let me just make sure we've got the. Yeah, I think you get reasonably unique characteristics. So we always like to make sure that the hardship has been documented. I think you've done that. I guess I have no further question. And seeing that there isn't much of an audience, I'll ask anyway. Are anyone in the audience that has questions of the applicant? Anyone in the audience that wishes to be heard either in support or?
I'd rather not ask any questions of my daughter. Thank you very much.
Okay. Is there anybody in the audience that wishes to be heard in either support or opposition to this application? All right. For the board members, one last chance.
All set.
Okay. Then could I entertain a motion to close this hearing and we'll be able to deliberate on it?
Sure. Liz, you want to take it away?
Okay, I'll move to close the public hearing for the dimensional variance for 27 Dean Road.
Second.
Oh, it's been moved and second. I was afraid it's going to die for lack of a second there for a second. Anyway, it's been moved and seconded. Any further discussion? All those in favor, John, aye. Liz?
Aye.
Mark?
Aye.
Motion carries. So we will deliberate and hopefully this evening render a decision for you. We'll give it to the town clerk once it's written up and they'll notify you. That's when the clock starts, and presuming you're successful, there's a statutory 20-day appeal period during which anybody can appeal this. And presuming, since we haven't seen any opposition here, that isn't going to happen, you then take it and register it with your deed at the court and go to town.
Okay. Awesome. Thank you for your consideration.
Well, thank you for your patience. You, we had been smart,
suffer through the long one
slightly differently, but you get the opportunity to see what happens when
from a theoretical
don't
point
go
of
as
view,
well as
very
we like.
Very informative.
Yeah, right. And with that, we'll go. So, guys, shall we? You got time to deliberate?
Yeah.
Yeah.
Sure.
Thank you.
Good night.
You're very welcome.
Good night.
All right, so we have Fairview Lane. That was our open space variance.
Oh, yeah.
That so just as I understand, when his references to existing zoning bylaws are references to the open space version. So if this had been, and Karen, this is just, you can confirm or deny, if this had been presented today, the whole thing, and it included this wouldn't require a variance, presuming all the other aspects of the application met the current open law. But if he were to compare this to just any lot in town under that thing, they'd be, it's like 40 feet and 30 feet that he'd be seeking relief from, right? If it was not under the open law. I mean, but his references to existing zoning were the existing open space statute, I think, which I don't think I called caught going in, but because I thought those numbers seemed weird that they'd be legal. Now I get it. Anyway, what folks' sense on it? Do we have a problem with it?
No, I don't.
I don't either.
Because the neighbors are fine, and you know he's going to line up with the house next door, and all the houses in the neighborhood are roughly this distance from the street, so you know not going to derogate from the other structures.
His he did better than most at actually coming up with a unique and financially, he actually put numbers as a financial hardship. I think that's maybe the first one in my time on the board that's actually calculated the financial hardship, or otherwise usually it's just a bad look. So okay, so where are we to grant this? What conditions do we want to put on it?
So Karen, does he actually have plans for the house? That's one thing we didn't ask for. Do we have any renderings of anything?
Nope.
All right. Yeah, it's weird because it does. Well, we could ask as one condition that they he submit a set for approval if we want. He also said that it's roughly 4,000 square foot home. We could reference that just to keep it.
And then if we do the standard catch-all of being substantially similar to other homes in the neighborhood or something like that.
Well, yeah, I don't know whether we didn't actually ask him.
Yeah, we didn't.
Assume it's similar, but similar in scale. Yeah, that is. There really is an actual plan, just a site plan, but it refers to a specific building. Okay. Complete dimensions. Well, we could ask if we want for plan that the plans be submitted and approved by the board if you want to get into that. Not sure I do, but
yeah, I wonder if we could just add some kind of conditionary language. I don't know, you know, in terms of I don't know how to phrase it in the sense that it's, you know, it's got a huge lightning. What would we say for, you know, blending in with the community? I mean, blending in with the neighborhood, or, you know, the scale of the house is, you know, not too big. I don't know how to say it.
Yeah,
that's hard.
Yeah, we should ask them that.
You'd say approximately 4,000 square feet. I mean, he did say that, and we say approximately means if it's, you know, a little more, that should be okay. I mean, I guess the word, you don't want a monstrosity going in there, but.
Yeah, my guess is either we should ask for the right to review and approve it, or stay away, because if we start putting vague language, we're just asking for trouble.
Yeah.
I think we either, if we can't say specifically it wants to be in accordance with the plans, we either take it on faith or we say we want to see it and approve it. Yeah, I wish I don't know why I didn't ask. We usually do, and I didn't think of it. So how about if we put in a condition that says, well, we could put in decision that if we approve it with this and put a condition on the specific distances, which he was pretty clear on, which was 15.8 feet to the right side. Let's be real careful with our directions. Which is right side. Which direction is that? Let's see.
I don't have the plan in front of me. I'm having trouble accessing the Town of Holliston website to get the documents for whatever reason.
I have it here, but I'm just trying to get. Okay, so north is, I think that would be the north side lot line. And this is going to really put us into, Mark has a different interpretation of nearest point of the structure than our previous building inspectors. So he allows for the overhang, which means they really want it closer than 15.8 feet under our old figuring by whatever that is. But
it's actually, John, that's actually not an interpretation issue. The bylaw was actually changed, the definition of dwelling.
Oh, beautiful. That's great. What is it?
In 2019, it's one 18, I'm sorry, it's one of Chris Canny's changes to the bylaw. It's in the definition section.
Okay, here I have
under
it here.
1E.
Oh, that's, why did I not know that? That's terrible. I feel embarrassed.
I think it's under dwelling.
Dwelling unit, dwelling. Building or portion thereof designed exclusively for residential occupancy, including single family, two family, multi-family dwelling and apartments, but not including hotels, motels, boarding house, trailers, mobile homes, or structures solely. I wonder if I have, no, this is the May 6, 2019 version. So
could be under, I thought it was dwelling. It could be under setbacks.
Yeah.
It's under a definition. So the
setback
change would be tracked by
okay, yeah, excluding the eave, provided, however, that where the eave is greater than 2 feet in width, the setback shall be measured to the eave. Okay, beautiful. So we don't have to ask every single applicant. In fact, but we still have to ask about stairs and things. Mark was clear that that's part of the structure. So as I have it, it'd be 15.8 feet to the north side lot line, no closer than that, and no closer than 30 feet to the front lot line. Yeah, and that was the steps, so he's hopefully he seemed pretty clear on it, and Mark was on the call. So what if we were to use a something that it says that the house shall be approximately 4,000 square feet in an architectural style and material palette consistent with the neighborhood, and shall be submitted to the board for approval before issuance of building permit or something like that. Is that?
I think it's a good catch-all. I like it.
It's going to mean we have to look at it, but since we didn't ask for it, and it's you know, he may have it already. We may be able to do that next week, but
I think Liz just took a lightning strike.
Oh, okay.
She's gone.
Great.
Yeah, I just had a huge clap out here too.
No kidding. All right. So yeah, we can't really do much more. Well, let's see. What else do we have? We can review any of these when she gets back.
Yeah,
Anything
Liz
else?
just texted me that she lost power.
Okay. Anything else, Mark, that we would want to condition this?
Not on this one. I don't have a problem, especially given the
file it with the registry and whatnot. I wonder if she can get back in on by phone.
She says she's trying.
Okay. Karen, on our friends on Pearl Street.
Yep.
I mean, if he pushed it much further, I would have been happy to make a decision tonight, and I knew what that decision would be based on my decision. It may not change much, but is that a problem? Are we creating problems for town council in the lawsuit with anything we do with this?
He sent 2 emails during the hearing, but he didn't speak to that issue. He spoke to the procedural issue of the time and then getting the record because we had scanned it to him previously.
Okay, great. I mean, yeah, I don't think we're going to have any surprises with what we see, but I'd rather say I think we want to be real. It's going to get appealed no matter what, I guess, but the more we can get into the substance of this, the better. Hi, Liz, you're back.
Hello, Liz.
Hi, Liz. Oh, she's still getting on audio. There she is. Can you hear us now? You're on mute, but
I'm on my phone because we lost power for a second.
I know, that's miserable.
And my computer, I think my router is not back up yet, so I can just continue on my phone.
Yeah, that's fine. And we should be pretty quick. The only thing, we were just going through the conditions, and were you still on when I suggested the one about us approving? And I don't know if that was before or after we lost you.
Approving, say that again?
That the house, a condition that the house be approximately 4,000 square feet in architectural and materials palette consistent with the nature of the neighborhood, and that the plans be submitted and approved by the board prior to issuance of the building permit.
I missed that, but that sounds good.
Does that seem reasonable?
Yeah.
And the only other thing that we had other than the dimensional piece was the registry. Can you think of anything else that we would want to condition it on?
No, I mean, the neighbor got some assurances about the trees or something, but.
Yeah, but I see his point. He was a little surprised because you see that plan, he's up in the top front corner, and that neighbor's the opposite. It's on the other side of his leach field. I don't think would go anywhere near there, but yeah, we could.
We need to say anything.
Yeah, I don't think that's a zoning issue. That maybe.
Right.
Yeah, he got what he was concerned about, and the guy that's close to him is the one that said he was good with it first. So, all right. Anything else?
Nope.
All right. So you want to make a motion?
Sure. Make a motion to grant dimensional variance at, sorry, got the wrong address here, 115 Fairview. Is that correct? Yes. To grant that the side setback be no closer than 15'8" on the north side or right side of the building, and no closer than 30 feet to the front.
Yeah.
As well as the other conditions we discussed.
Yeah, and I think we found the findings would be that it was constructed under special permit for cluster development under conditions that have since changed, that there was a hardship owing to the unique condition of the land, given the location of the septic and the existing structure, as well as the shape of the land. Wait, this one, he had a curve too, right? I guess it didn't really. I guess that doesn't really impact his thing, but there was ledge, there was existing septic field, existing structure, all of which limited any opportunity to build.
I think I have to second it.
Okay, yeah, I just was figuring the rest of the decisions in there, and then we want to say it our normal, it's not in derogation of the bylaws, etc. So, okay, it's been made. We have a second?
I'll second.
Okay. Further discussion?
None.
All those in favor of granting the variance as we spoke about, John, aye. Mark?
Aye.
Liz?
Aye.
It passes. Okay. Then we have our other friend at 27 Dean Road. I always feel bad for people that have to sit through that kind of stuff and then have a 5-minute hearing. But as her father said, it was interesting to see. So, any concerns with this one?
No.
None for me. I know the spot.
Yeah.
So none for me.
Yeah.
Be a nice addition in the neighborhood.
Yeah, and I think that as she stated, the unique characteristics are there, that she has preponderance of frontage, location of the current septic, the current structure limit the opportunity to construct anywhere else, and that as far as the deck goes, limiting it would make it unusable. And the other is pretty diminutive in terms of the changes made. So what conditions we have? We've got a few dimensional ones here, that well, I guess first that it be substantially in accordance with the plans submitted, that the proposed building addition on the, which direction? I guess let's try and get north side of the house be no closer than 25 feet to the front lot line, and that the deck structure on the south side be no closer than, let me say 26 feet, give her that half foot, to the south side, that is side, right? Lot line.
Yeah, I would just say south side. Yeah, I believe it is.
Yeah, that would have to be
yeah,
side.
it's
So
the
that's
side.
referencing. Yep. So we have that in accordance with the, substantially in accordance with the plans and things, that it be registered. Anything else that?
No, just reference the,
the
plan set and the date.
Yep. And we don't even have to mention the materials and all, because they're kind of all shown on the plans. Okay. We've hit the hardship, little enforcement. It's, the house is consistent with other houses in the neighborhood. The changes are not substantial to anything that's going on there, and so it really wouldn't derogate and be any detriment to the public good, and should enhance the neighborhood. Okay. Anything else?
Think of anything.
That being said, could we have a motion for that?
Sure. Make a motion to grant the request for dimensional variance by Jennifer Buckner at 27 Dean Road to encroach no further than 25 feet to the north or front setback and no closer than 26 feet to the south or side yard setback, among the other items we discussed.
Yeah.
I'll second it.
Move second. Further discussion?
None.
All right. All those in favor? John? Aye. Mark?
Aye.
Liz?
Aye.
All right. Motion carries. There we have it. So, hey, thanks guys for making that work for next week. I'm like you, will feel better, at least having read all of that stuff and making sure, because I'll tell you, my memory is a lot different than what they were saying.
As is mine, and I was just waiting to see how it played out, but I was about to say something else. But yeah, I'm glad it's next week. Let's get a look at all the documentation. Yeah, Liz, that was a great suggestion. But yes, the public hearings were very different than what Attorney Bingham presented.
Yeah, but and I do. Yeah, I think there is a problem. We I guess just tells us to be real careful in those directions and some of that wording. But to me, that's ambiguity that is up to our interpretation, that as opposed to, I don't think if he wants to take it to court and let the judge decide whether language speaks for himself, that's what a judge does. But I think we want to do. And Karen, I think for this one, we better work on making sure we've got, a lot of that stuff into the findings of fact, because I'm sure he's going to appeal it. So I can work with on that one as well. But we'll do it. And thanks for being available. And let's not put anything else on that. Let's read our stuff. Give anybody a chance that hasn't been heard to say anything that we haven't heard. Now, when did Jay say he was going to be back? Is he?
I think the 5th or the 6th.
Was it? Yes, I agreed. I think it was the 6th.
Oh, it's because if he wanted, he could watch this tonight and participate. He was involved with the first.
Oh no, it is the 5th. So great.
All right, I'll send him a note, explain, and if he wants to, he can do it. I mean,
I'll get him the paperwork for the.
Yeah, copy him on everything we do, and that'd be interesting because he's relevant. He was both part of both decisions, and
Oh, yeah.
Is one more memory that I'd love to have. I was really anxious to have him here. I don't know how I missed the original one, because I remember the original case, but I wasn't on it, so I had to have missed the meeting. But I know I read the application though. That's what kills me. Yeah. Oh, we didn't bother to put the application in. Yeah, because the application says.
Yes, exactly. We'll all read it.
Yeah, and yeah, Southwest.
Moving on.
Exactly.
We'll discuss it outside of the hearing.
Gotcha. Let's adjourn.
Okay, I'll make a motion to adjourn.
I'll second it.
All those in favor: John, aye. Mark,
aye.
Liz,
aye.
Thank you very much.